Why is one divorce case more difficult to settle than another one? This is an interesting question, and I can tell you from my years of experience on the bench and as a mediator that while sometimes it's the complexity of the issues involved, more often than not, in my experience, it's not that. It's the mindset of the parties. You could have a very complex case involving all kinds of issues, and the parties, because of their demeanor, the way they treat each other, the way they participate in the process, it becomes very streamlined to resolve the case peacefully. And in other cases, while the issues may be relatively simple on paper, the mindset of the parties, the animosity between the parties creates additional friction and additional unnecessary hurdles that the parties have to overcome that makes it much more difficult to settle a case, even when the issues are relatively straightforward. And those cases tend to go on and on and on, and tend to cost the parties perhaps more money and time and energy than is otherwise necessary if one was to look at this objectively. So when you look at the mindset of the parties, it becomes very relevant in terms of how to try to move a case ahead peacefully and to a mutually acceptable resolution. Family court in general is what's called a court of equity. Equity generally means fairness, a court of fairness. What that means is that the strict rules that may apply in, for example, a contract case between two arm's length parties, a vendor and a purchaser, that type of thing, may not necessarily apply as neatly in family court. In family court, the judges generally have a tremendous amount of what's called equitable discretion to do what the court feels is fair and equitable under the particular factual circumstances of the case. And this is very important for parties to consider and keep in the back of their minds, discuss with their own attorneys if they're going into a settlement conference, for example, or mediation, or simply discussing how to potentially resolve the case, that no two cases are exactly the same. And so it's relevant to consider the reality that a court may see things different than you do in terms of fairness and equity. And very often, particularly after I retired from the bench and became involved in mediation of family court matters, it became obvious that when parties came to the table for a settlement conference or mediation, that very often both parties had a very different perception as to what was fair or what was equitable to them. And those differences had to be resolved, sometimes to some degree compromised if you were talking about reaching a settlement that is acceptable to both parties. So very often parties, in considering what was fair, considered what was fair only to them. Their focus was only on them. They didn't really care so much about the other side because of the backstory, because of their feelings, very often negative feelings about the other side, their ex-partner. And they quite frankly took a position that I don't care what happens to him or her. I only care about me, which is, understandable to some degree, but it's unrealistic when you consider the fact that to get a settlement in a case, it has to be something which is voluntarily acceptable to both parties, not just one. So when you take a position that I only care about what's fair to me and I'm not looking at it in any way from the other side, that tends to prolong a case sometimes. The other reality is that in family court, principles of equity apply. And so therefore, quite frankly, you could have 10 different judges, theoretically, look at the same exact case and get 10 different results. And it doesn't mean any of those results are wrong. It simply means that's what that judge in that family court found to be fair and equitable under the totality of the circumstances. So there are no guarantees as to what's going to happen in court. And if in fact in your situation, if you are consulting with your attorney, you want to have this discussion with your attorney as to at least what they believe is more likely than not to occur in court, understanding that nobody has a crystal ball and you could have the greatest attorney in the world. It doesn't mean that they can predict or foresee how the evidence is going to come in, how you or anyone else is going to testify in court, how persuasive or non-persuasive you're going to be, and what the court may decide is fair and equitable under the totality of the circumstances. A judge has to deal with two sides, not just one, sometimes more than two sides, depending on the nature of the case, if there are three or more parties involved. And if a party comes into a settlement conference with a very rigid and inflexible view of fairness, in other words, their view of fairness is only that they get everything they want, that may tend to prolong a case because that may not be, in certain cases, realistic in terms of how a court may view the situation. A lot of people bring into a settlement conference or mediation, a whole backstory in terms of everything which happened in the marriage, carrying it around like a bag of heavy rocks that weights everything down. And quite frankly, some of the information and some of the content of that bag of rocks may not be relevant, or a court may not feel it's relevant in terms of deciding what is fair and equitable under the totality of the circumstances. Very often, when I was on the bench and I would reach a decision on cases that did not settle, whether they involved custody, parenting time, child-related issues, even non-child-related issues, alimony, division of assets, other issues, what I tended to do is I would not just do a written decision. I would tend to have the parties appear in court because I wanted to explain not only what the decision was, but why I reached the decision. And it was obvious to me from watching the visual reactions of the parties when I was reading the decision and explaining that there was very often surprise by both parties, sometimes their attorneys, as to the decision. They were surprised. And while I'm not a mind reader, I could almost tell in many of these cases that they were thinking something along the lines of, well, number one, we're disappointed with the decision because we expected something more one-sided towards me. And on top of that, that they could have resolved the case months or a year or longer earlier at substantially less cost and substantially less time and substantially less aggravation and negative experiences and stress had they simply resolved this or attempted to resolve it much earlier. In other words, sometimes people went into court just assuming that the way they thought about fairness, the way they thought about equity was exactly the way the court was going to see it. And that's not always the case. Sometimes the evidence doesn't match up. Sometimes the court doesn't agree with your view of what's fair. The court has to balance both sides and has to consider the facts and the law. So sometimes people would stand there, with their mouths dropped open, shocked, sometimes both sides, shocked as to the decision. Doesn't mean the decision was wrong. It means that their perception or in their minds, their mental guarantee of outcome or what their friends told them was going to be the outcome did not necessarily pan out. And it cost them a lot of money and time and energy, negative energy, to get to that particular point. This is why most cases settle. It's simply because the risk of going to trial and the cost of going to trial and the fact that your interpretation of what might be fair and equitable might not be exactly how the court sees it is a real consideration in these types of cases. Now, as a mediator, what I very often do is ask parties a hypothetical question. And I say to them, if you were to judge in this case, and if you could write your own order determining how these things were going to turn out, how these issues were going to resolve themselves, and you can write that with one condition, one, that it has to be fair to both parties under all the circumstances, not just fair to you, but fair to both parties, what would you write? And why? And I can share with you that many people are unable to answer this question. Number one, they don't even know what they're asking for. They want justice. That's a very general term, but they're not asking for anything specific. And when they are asking for something specific, if it's too top-sided towards them, it becomes very difficult to answer the question, how is it fair to both parties? So you may want to ask yourself in consultation with your attorney, what is it you're asking for and how is it fair to both parties? If it's fair to both parties and your attorney can argue that it's fair to both parties under all the circumstances in court or anywhere else where it may be relevant, then there may be something to go on. There is an old adage that says a good settlement in a divorce case or a family law case is when both sides leave unhappy It means both parties are compromising their positions. It means both parties want something different, but for the sake of getting a case done, and also for the sake of a child in certain instances to promote peace, to create peace, and sometimes there has to be some compromise. For children, as the child in point C, it's critical for parents to keep in mind the best interest of the child, and sometimes the best interest of the child is to resolve a case. That doesn't mean to sell yourself out or sell your child out, but sometimes compromise is helpful and relevant in terms of essentially permitting both sides to move on with their lives, rather than getting caught in the trap of staying in court for months or years and hoping that whichever judge you happen to get sees things exactly the way you do, which may not be the case, might not be the case. And if you're able, in the context of a settlement conference, to address your issues but reach a resolution that both sides can live with for the sake of a child and create peace for the child, you may be helping reach an appropriate point C.